Langat from the Daily Nation, there is a principle in law that there must be an end to litigation. Parliamentarians are the lawmakers. They are the ones who made this law. There were two cases that preceded the decision by the Chief Justice. The first case was decided by Honorable Lady Justice Mumbi Ngugi, in which the National Assembly and the Senate, as well as the Attorney General, were parties. The second case was decided by Honorable Justice Mativo, again in which those three individuals were parties. The order was transmitted to them when it was delivered. How else would they have wanted the order to be transmitted to them? By registered mail? But more importantly, the Chief Justice, upon receiving a petition from Margaret Toili and David Sudi, did write to the speakers of the National Assembly and the Senate and asked them to explain what steps have been taken before he could act. The two speakers responded, and in fact, they sought more time. They therefore have knowledge of the making of this order. I seem to have forgotten your last question. Could you repeat it?
The 11th Parliament, the argument that the order
Okay.
by the 11th Parliament.
Good. Parliament is parliament, just as government is government. We cannot say that we'll disregard all contracts that were entered into by the government under the leadership of President Mwai Kibaki, now that we have the leadership of President Uhuru Kenyatta. Parliament succeeds in perpetuity. Parliament has failed to comply. It is this parliament that is liable to be dissolved. That argument is unsustainable. In fact, the argument was raised before the Court of Appeal and it was dismissed by the Court of Appeal. This matter has reached its finality.